If they appoint me as a company secretary, I can work in only one company. I cannot be a company secretary for more than one company. This is the law, what it says for us. Before entering into contract, he has to verify, because he is going to be entering the contract through in the name of the company, not as an individual person. The auditor's appointment is very important for all the organization, and he should not be an employee of the organization. Welcome, my dear students, for BCom Second Sem Company Law Unit 3, Session 3 of Company Administration. I am Professor Rajesh Ella from Department of Commerce and Management, Vidhyaashram First Grade College, Temple of Excellence, MYSURU. In previous session, we learned about whole-time director, independent director, as well as company secretary and his functions. In today's session, we are going to discuss about the company secretary's powers and who is an auditor and the appointment of auditor, powers and duties of the auditor and removal of the auditor and subsequent auditors and his termination. So, the rights of the company secretary. In the previous session, we have discussed about the functions of the company secretary. In today's session, we are discussing about what are the rights of the, if I am a company secretary, what are my rights are there. So, I'm going to supervise, control and direct all my subordinates of the organization. I'm going to observe each and everything, whatever it is happening in the organization. I means here, company secretary is going to observe every moment in the organization and is going to control all the activities of the company here. And he can sign, authenticate the proceedings of the meeting. Whatever the meetings are conducted in the organization, he is having all the rights to sign the meetings. And he is a person who has to sign the meeting records and submit the same to the ROC. And next, he is having the right to blow the whistle whenever he finds necessary. Means he is going to take action whenever it is required, and he is going to involve all other directors at the time of requirement here. He can attend the meetings of the shareholders and the board of directors. He is having all the rights to attend any type of meeting. It may be a board meeting, AGM, annual general body meeting, shareholders meeting, class meeting, and he has to record all the information which are discussed in the meeting, and he has to sign the records as per the provisions of the Act. Last, at the time of liquidation, what is his duty and how the creditors are going to claim and how the settlement has been made with the support of the liquidator. He is going to monitor and is going to check that for whom the amount has to be paid first and why they have to pay, and who will be the second creditor. First will be secured and then preferential, and third it will be unsecured creditors. At the making of the payment, he is going to discuss with the liquidator and they're going to take right decisions here. Procedure for appointment. If they want to appoint any company secretary, then the first duty of the company is to provide an advertisement in the newspaper stating that one requirement of a company secretary, as well as the detailed information of qualification required and the experience required for the particular position. That is the call for application. After receiving the applications, the company has to scrutinize all the application. Then they have to hold an interview for the shortlisted resumes, and they have to finalize the terms of the appointment. After scrutinizing and making interview of the person, they have to scrutinize in such a way that which person is suitable for the company secretary position. They have to check that a right person for the right job at the right place. This is the concept of the HR should be there, and they should not appoint a person who doesn't have a knowledge of secretarial work, even though he is a qualified person. So then giving notice to all the directors about the board meeting and convey board meetings at such a place, time, day decided by the board. They're saying that when the board has to give certain information to all the participants of the meeting here, stating that one, the appointment of the company secretary. So they have to decide that one in the meeting. So first, the meeting information should be conveyed to all the board of directors about the date and time and place where the meeting will be conducted, when they're going to conduct it, and what is the meeting's agenda. So they can get prepared for that one. And in the meeting, they have to get the approval for appointing the company secretary, and the same has to be conveyed to the ROC. And next, inform the registrar about the appointment of company secretary. After the appointment of company secretary, just inform to the ROC how they appointed the secretary and what was the procedure they have followed. And even they have to inform to the listed organization within 30 days by submitting DR12. DIR12 means they have to submit a form called DIR12 and they have to inform to the ROC. And next we have here, a company secretary is not allowed to hold office more than one company. If they appoint me as a company secretary, I can work in only one company. I cannot be a company secretary for more than one company. This is the law, what it says for us. And make proper registers of directors and key KMP and make necessary entries in it. The duty of the company secretary will be to maintain certain register books and recording the information as per the law and provisions, what it says that one. Now, that register of directors he has to maintain in that one, name of the directors, addresses of the directors, and their role, whatever it is, say that one, and whether the directors have subscribed the shares or not. Everything has to be recorded and should be maintained here. And detailed information of CEO, CFO, COO, vice president of the departments or the projects, whatever they have, and every information, whatever it takes place in concern with these people, that should be recorded in the registers. Informing the stock exchange where the shares of the company is listed. As I said earlier, after informing the ROC, they have to inform the stock exchange in which stock exchange our company shares are listed. The next one, the statutory, the norms we are going to call, duties and liabilities of the company secretary. Authentication of documents, verifying the documents properly, proceedings and contracts. Before entering into contract, he has to verify, because he is going to be entering the contract through in the name of the company, not as an individual person. So now he has to take decision before entering to the contract whether the contract is suitable for our organization or not. Signing share certificate, signing annual returns, is having all the rights to sign the share certificates and is having rights for the signing all annual report which has been prepared after 12 months. Signing the financial statements, trading account, profit and loss account, balance sheet, cash flow. He has to sign all the financial statements. And if in case any issues takes place, he should appear in front of the tribunal and demat shares. And next, additional duties, whatever it is said, he has to follow according to the norms of the Companies Act 2013 as well as Secretarial Act of 1980. Procedure for removal. Now, we have discussed in the section about appointment. The next concept here, removal. If they want to remove any company secretary, means they have to satisfy all the terms of appointment and the board is liable to record the same. Means at the time of removing, whether at the time of appointment, whether they followed all the procedures, and now they're going to follow the same type of provisions at the time of removing any secretary. The board has to pass a resolution after giving a notice to all the directors of the company about the matter of removal or resignation of the company secretary. The board has to convey to all remaining members stating that one, we are going to conduct a meeting to discuss about the removal of the secretary or his resignation from the position. Then they have to decide if they're going to remove, means why they're removing the company secretary. Whether they made a contract between the company secretary for only number of years or number of days. Then how they are going to remove and what are the strategy they are going to adopt for the removal year. File Form DR12 in electronic mode within 30 days with the registrar of company. As soon as the meeting is over, after the removal of the company secretary, the board of directors has to submit DIR 12 form to the ROC through electronic mode within 30 days, informing that company secretary's removal, and they have to pay certain amount for the process here. And even immediately they have to inform the stock exchange about the removal of the company secretary and make necessary entries in the register that is maintained for recording the particulars of company secretary. Whatever the books are maintained or the registers, what we are going to call, in that clearly they have to mention that one, why a company secretary has been removed, for what purpose, whether he was involved in any illegal activities or whether his appointment tenure is completed or whether due to certain conflicts rise between the shareholders and the company secretary, he has been removed from the position. Everything has to be recorded as per the information are available with the board of directors. Next, the auditor is compelled by the law to examine the books of accounts maintained by the director and inform about the true financial status. They're saying that when the auditor has to verify the books of accounts at the time of the company secretary, how he has maintained and what are the transactions were taken place, and all the information has to be submitted to the board of directors at the time of removing any company secretary. And all the companies registered in India required to appoint an auditor who audit all the books of accounts. They are saying that when if books of accounts are to be verified, they have to appoint an auditor for taking care of all the verifications of the transaction which are taken place in the organization. Now, after the company secretary, we are going to discuss about the auditor. Appointment of first auditor for our organization. If we have commenced our business in the current year, we are going to appoint an auditor. So then we are going to call him as the first auditor of the organization. If any auditor is appointed for the organization to verify the books of account, what we are going to maintain in the upcoming days and which books are to be maintained, how we have to maintain, means we have to get the suggestions and the guidance, or is going to be a mentor or coach for our company. And as per the directions, whatever he provides, that when the company has to maintain the books of accounts and the financial statements. And the auditor's term will be for 5 years as per the provisions of the Act here. And the auditor's appointment is very important for all the organization, and he should not be an employee of the organization. If he's an employee, he cannot become the external auditor of the organization. And his first appointment will be based on the CAG, Comptroller and Auditor General of India, in case of government company. And the time period for the appointment of first auditor is 180 days from the commencement. They're saying that when if we have commenced our business today, that is on 19th June 2023, within 180 days I have to appoint the auditor, or else we are going to face certain issues with the ROC. In non-government companies, the first auditor is appointed by board of directors. Who is going to appoint the auditor here? The board of directors within 30 days of the incorporation. As soon as I receive certificate of incorporation, within 30 days I have to appoint my first auditor. If board of directors is not liable to appoint, then they inform the members about their failure, and after that the members shall appoint the first director as well as within 90 days from the date when the BOD informs. In case if the board of directors failure to appoint any auditor, first they have to appoint a director, then they have to appoint an auditor for the organization. Appointment of subsequent auditor means every company shall appoint subsequent auditor who hold the office from the date of first AGM till the conclusion of 6th annual general body meeting. As I said that one, after appointment of first auditor, if they want to appoint a subsequent auditor, his appointment will be for a period of 5 years. After completion of first AGM, after completion of first AGM up to 6 years, means up to 6 AGM, the auditor will be termed as an external auditor of the company. And for any auditor, there will be no second term. In case if they want to provide the second term, that is next 5 years, then a special resolution has to be passed in a class meeting, and all the board of directors has to give approval for the continuation of the director appointment. In government company, the subsequent auditor is appointed within 180 days. In non-government company, it is appointed within 30 days of the organization. They're saying that when if I want to appoint any director for government company subsequent auditor, then within 180 days I have to appoint. And if I want to appoint subsequent auditor for non-government companies, within 30 days we have to make that one. Procedure for appointment. The entity should obtain a written consent and a certificate before appointment is made at AGM. Auditor should certify that. Means they are saying that when they have to collect particular documents from the auditor as per the discussions which took place in the annual general body meeting. Individual or firm is eligible for appointment and is not disqualified for appointment under. They're saying that when they can appoint any individuals or a firm, limited liability partnership nowadays, which is coming across the world, LLP, where a chartered accountant will start the organization. They're going to become the external auditor for the organization. There, the firm, they're going to appoint a firm, not as individual. The Companies Act 2013, Compliance Section 141 says that when the appointment of the auditor, and the Chartered Accountant Act 1949 says that when this person is qualified from the ICAI and all the rules and regulations made there under, means they are saying that when what are the provisions are there at the time of appointment of any auditor, they have to verify that whether he is a qualified auditor or not. And the proposed appointment is within the limits laid down by under the authority of the Act. They're saying that when certain rules and regulations are framed for the appointment of auditor, that he should be a qualified person, whether his background is perfect or not, and whether he is eligible to become the auditor of the organization. And all the board of directors has to take a decision, and then only they're going to appoint any auditor, either it may be a first auditor or subsequent auditor. The term and rotation of auditor, Section 139, subclause 2, Rule 5 says that one, for the continuation of the auditor, rotation of auditor is a new topic introduced in the Companies Act 2013. Earlier in Companies Act of 1956, there was no rotation of the auditor. Rotation means reappointment of the auditor for the second term. After specified time, it means the same auditor cannot continue forever. See, they are saying that the same auditor is not eligible to continue the second term. If he has to be continued, all the board of directors has to give the approval with a special resolution. Rotation is applicable only to listed companies. They are saying that when if our company is listed, there will be a second term for the auditors. Other prescribed class of companies, except one person and small companies, doesn't have the rights to rotate the auditors. List all unlisted public companies having paid up share capital of more than or equal 10 crores can give the rotation for the auditors here. And companies of all private limited companies having paid share capital more than or equal 50 crores, they have all the rights to give the second term for the auditors. The above company shall not appoint or reappoint an individual as auditor for more than one term, 5 consecutive years, and an audit firm as auditor for more than 2 terms for 5 consecutive years. They are saying that when for rotation basis, if they want to appoint, special resolution has to be passed, or else for any company, it may be that when either any part here, they don't have the rights to appoint for the second term. They have to appoint a new auditor by passing a resolution. Qualification of an auditor. A person shall be eligible for appointment based on the Chartered Accountant Act of 1949. He should be a qualified person from the ICAI. In case of a partnership firm, company appoints the firm, not the partner, or in individual capacity. If we have a chartered accountant partnership firm, they appoint the partnership firm, not the partners here. So both the partners are external auditors of the company. Where a firm including a limited liability partnership, as I said, you appointed as an auditor of the company, only the partners who are chartered accountants in LLP, limited liability partnership. If all the partners are chartered accountants, then the firm will be appointed as the auditor. If the partners are all the partners are not chartered accountants, like for example, in our LLP, there are 3 partners, A, B, C. A and B are chartered accountant and C is a cost accountant or company secretary. Then A and B, who are chartered accountant, they'll be appointed as auditor for external activities of the organization as well to monitor the financial statements. Thank you, my dear students. In today's session, we learned about the functions, powers, role of company secretary, as well as the first auditor and the subsequent auditor and his rotation for the benefits of the organization. And the conditions are as per the Companies Act of 2013. Thank you.